Welcome to today's Explainer, where we're going to unpack the delicate historical bargain of intellectual property. Now, we often think of patents and copyrights as these purely modern corporate tools, right? But today, we are going to explore the historical pressure valves that were built directly into intellectual property, specifically to ensure that ideas eventually flow back into the public domain. We've got some fascinating history to cover, from the progressive era all the way to modern pharmaceuticals, to really understand how this system was designed to balance private reward with public access. So you might be wondering, who really owns an idea once it's out in the world? It's super easy to assume that patents and copyrights were always intended to be absolute permanent monopolies. But honestly, that's just not true. The whole concept of intellectual property has always been a bit of a tug of war. Is it the inventor's property in perpetuity, or is there a specific moment where the public's right to that knowledge takes over? Here is our roadmap for today. We'll be hitting the intellectual property bargain, origins of the public domain, justice story and fair use, the social obligation principle, alternatives to strict monopolies, and finally, protecting the innovation cycle. Starting with Section 1, the intellectual property bargain. Think of innovation and culture like a giant production line. You've got raw materials, the inputs, and you have your final inventions or books, the outputs. If you give creators exclusive, unbreakable monopolies over those outputs, you naturally risk jacking up the cost of inputs for the next generation of creators. Finding the sweet spot in that system, that is the absolute core of the intellectual property bargain. There's a really stark ideological contrast at play here. On one side, you have this post-revolutionary French philosophy. They viewed the bond between an author and their work as deeply intimate, almost sacred, a natural right that made the author the absolute owner. But then, on the flip side, the Anglo-American model takes a much more utilitarian approach. It treats a patent not as some absolute right, but as a deliberate market-based contract negotiated with society. In this model, the public's interest is actually equal, if not superior, to the creators. The U.S. Constitution's IP clause relies heavily on this exact utilitarian concept. It authorizes exclusive rights for limited times, specifically as a tool to maximize the production of and public access to intellectual creations. It isn't really about an inherent moral right. It's an economic lever pulled to enrich society as a whole. Even way back in 1838, legal observers recognized that these state grants were established simply as a tacit contract. It's a fair compensation traded in exchange for the ultimate enrichment of the public domain. And the catch? Once that contract expires, the work belongs to everyone. Moving right along to Section 2, origins of the public domain, let's see how this utilitarian philosophy laid the groundwork for the earliest legal safeguards against perpetual monopolies. So picture this. It's 1774, and there's a massive legal struggle unfolding. A Scottish bookseller named Alexander Donaldson decides to print a cheap, totally unauthorized edition of a poem called The Seasons. Well, the London bookseller who owned the copyright sues, claiming he has a perpetual common law right to the work. But the House of Lords actually ruled in Donaldson's favor. They established that any common law perpetual right is completely superseded once a work is published. Basically, after the statutory period ends, it falls straight into the public domain. This single case effectively invented the legal concept of the commons. Section 3, Justice Story and Fair Use. Now, courts ultimately needed a practical way to let the public utilize parts of a work without totally destroying the author's commercial rights. It's kind of like usufruct in property law, the idea that you can use the fruits of the land without damaging the land itself. Justice Joseph Story articulated this incredible balance perfectly in 1841 in a case called Folsom v. Marsh. A reverend had abridged George Washington's letters into a new book, and the original copyright holder sued. Justice Story ruled that, yes, we have to look at how much was taken and if it hurt the original sales. But he also recognized something crucial. Unauthorized access for non-commercial, scholarly use is absolutely vital to democratic learning. And that historic ruling, it established the 4 factors of fair use that we still rely on today. What's so revolutionary here is that it defined property rights in terms of market impact, rather than absolute, rigid exclusivity. Think about it. If copyrights were treated as strictly as patents, it would severely choke off the very learning those laws were meant to promote. Fair use was the necessary pressure valve. All right, Section 4, the social obligation principle. Fast forward a bit to the progressive era, between 1890 and 1920. The industrial economy was getting severely disrupted by patent rings, basically groups buying up underlying patents just to extend their monopolies indefinitely and crush competition. The whole system was buckling. In response, courts developed what scholars now call the social obligation principle. This was a brilliant shift. It basically said that property rights are inherently relational. Yes, an inventor has a right, but they also owe a fundamental obligation not to pervert their patent, to harm the public, or hold back innovation. You literally couldn't use your state-granted monopoly maliciously. This 1917 Supreme Court quote hits the nail on the head. The court explicitly used the U.S. Constitution's IP clause to strike down restrictive, conditional licenses. A patentee was trying to tie patented products together just to corner the market. And the court said, no way. The primary purpose of the law isn't building private fortunes, it's public progress. That brings us to Section 5, Alternatives to Strict Monopolies. Because historically, when patent power gets too concentrated, the system hasn't just relied on judges. Governments have actually leveraged some pretty radical alternatives to keep vital innovations accessible to the public. Just look at this pattern. In 1624, Britain outlawed arbitrary crown monopolies entirely. Jump to 1917, during World War I, patent battles between the Wright brothers and the Curtiss Company had literally brought U.S. aircraft production to a grinding halt. So what happened? The government stepped in and forced a compulsory patent pool. Later, in 1975, U.S. agencies forced compulsory licensing against Xerox to break open the copy machine industry. The takeaway here is that when monopolies choke progress, the state historically steps in with big tools to ensure technologies remain accessible. Which leads us to our final part, Section 6, Protecting the Innovation Cycle. And this is where things get really relevant for us today. Scholars argue we're seeing a dangerous resurgence of unchecked monopolies right now, creating what they call patent thickets. These are incredibly dense, overlapping webs of IP rights that a company has to hack through just to commercialize new tech. Take your modern smartphone, for example. It is covered by roughly 250,000 active patents, from the battery chemistry down to the way your finger swipes the glass. That raises R&D costs astronomically and creates an absolute minefield for smaller competitors. The risk of navigating that thicket is staggering. It's exactly why Google dropped $12.5 billion back in 2011 to buy Motorola Mobility. Analysts noted they weren't buying it to innovate. They bought it largely to acquire Motorola's 17,000 patents to use as a defensive shield against lawsuits. It really illustrates how the modern patent system can act more like a tax on market entry than an actual incentive to invent. And we see the exact same thing happening in pharmaceuticals. Look at the biologic drug Humira. Its core composition patent actually expired in 2016. Normally, that's when cheaper generic competitors, or biosimilars, enter the market. But the manufacturer secured 132 granted patents, with the vast majority issued a full decade after the drug was already out there. Critics strongly point out that these continuation patents effectively act as a massive exclusion tool to delay competitors. Because of this specific thicket, biosimilar competitors were forced to hold off on entering the U.S. market until 2023. And during that legally enforced delay window between 2016 and 2023, Humira brought in more than $114 billion in cumulative U.S. revenue. Talk about a mind-blowing financial impact from delaying the public domain. So, what does this all mean for us today? With historical pressure valves like fair use and public obligation seemingly overwhelmed by these massive modern patent thickets, we really have to ask ourselves, are we still upholding the social obligation of the IP bargain? Have we completely forgotten the utilitarian purpose of intellectual property? Looking at how the system has course-corrected in the past leaves us wondering exactly how and when it's going to course-correct next. Thanks for joining me on this explainer, and as always, keep questioning the world around you.